Mr. Chairman, if I could weigh in on that just for a minute. Say I'm the compliance officer at Maryville College in my hometown, one of 6,000 colleges and universities, and I get a guidance telling me that in a sexual assault case, we're dealing with clear and convincing evidence, and that makes a change in whether it's clear and convincing or preponderance of the evidence. And I hear a Assistant Secretary of Education tell the chairman of the Education Committee that she expects everybody to follow that. To me, that's a change in the law that, in the first place, should not have been made by guidance, and the second place should be enforced by guidance. And then, in a practical sense, if I'm the compliance officer at Maryville College, I'm not going to take the risk of not following that guidance. I'm going to assume that that's the law, and that's not supposed to be. And so that let me shift over to the Labor Department, if I may, Mr. Chairman, just for a second. On August 27, the National Labor Relations Board created a big fuss in a case called the Browning-Ferris case. And it got into the area of what we call joint employer. And for those who are worried about the case, the joint employer issue means that for the first time, in my view, since 1984, the NLRB said that a franchisee, they say a McDonald's franchisee, and a McDonald's franchisor are a joint employer if, and it created a new standard for that, in my view, by saying that indirect control, let me get the exact word so I don't say it, a new standard by saying if the corporate entity, McDonald's, exercises direct or indirect control over, say, pay or working conditions, or even has the unexercised potential to do that, then the McDonald's and the McDonald's franchisee are treated as a single employer. And the problem with that for 780,000 franchises across the country is that encourages McDonald's to own all their own stores, and of all the small towns in America and the big towns too, you have fewer franchise opportunities, fewer contractors, because the big boys and girls don't want to run the risk of delegating all that to a franchisee. So that's a big change in the labor law. Yet the day before, there was leaked out to Politico a draft guidance from the Department of Labor instructing OSHA and its investigators to look at the same new test for joint employer. Now, OSHA is supposed to be looking at health and safety violations, I thought. So I guess I have two questions, Ms. Pat. One is that draft guidance something that you plan to make final? And second, if you're going to change the OSHA law, which goes back to 1970, to say instead of looking at health and safety, you suddenly want to have your investigators looking at a test for whether a franchisee and a franchisee are joint employers, don't you think that ought to be a change in the law that Congress makes, or at least a rule or a regulation? How could it possibly be done in a guidance?
Thank you, Senator, for your question. And I certainly can't speak to any decision that the NLRB made about this decision or about the Ferris case.
Kind of suspicious that they made the decision one day and this was leaked the day before from OSHA. Looks like a coordinated effort to change the law to me, but go ahead.
So actually, for over 10 years, the case law under the OSH Act has explicitly recognized that there's a concept of joint employment that applies. And there's many different work arrangements, so that when OSHA is going to a workplace to protect the work and safety, the health and safety of workers, they do have to look at these different work arrangements. There's temporary workers, there's subcontractors, franchising arrangements come into that, and there are elements of joint employment that could be implicated in that.
Well, wait just a minute. We're talking about health and safety, right? Isn't that what OSHA's interested in?
Absolutely.
And you have a multi-employer test that you sometimes may use, especially with contractors, and you may say that this contractor, and one might be a franchisor, one might be a franchisee, but it doesn't make any difference whether one has control over working conditions or pay or menus in that restaurant, does it? Why would you be looking at whether the franchisor is looking at the menu if all you're caring about is health and safety?
All we were doing in this, and I would say this was not a guidance document, this was a draft document of questions to teach investigators for the kinds of things that they should be looking for. This is really important because you need investigators having consistent approach when they're going into a workplace and asking questions. So that's what it was designed to do. And it was for that investigator to be able to be asking concrete questions about what they're seeing.
But since when did OSHA get in the business of trying to figure out whether you're a joint employer or not? Why is that why does OSHA care about that? Why isn't OSHA interested in health and safety? My father was the first chairman of the OSHA board in Tennessee. They were interested he was a safety director for many years. He was interested in health and safety, not whether a franchisor is in charge of a franchisee. Why would your investigators be looking at that?
So OSHA absolutely their focus is the health and safety of those workers. And in asking those questions, it's simply trying to better understand who is responsible for the health and safety of those workers. And if this is a topic that you would like to do additional follow-up with us on, we're committed to having more of a conversation with you about that.
Yeah, well, I would like to do a lot of follow-up on the joint employer rule because I think it's the biggest attack on the opportunity for small businessmen and women in this country to make their way into the middle class that we've seen in a long, long time, and to have OSHA perhaps through guidance join in with the NLRB just as even more of a threat to several 100,000 franchisees and millions of contractors across the country. Mr. Chairman, that's all I have.
No.